more about corporate regulations. Let's commit efforts to accustom this newly ventured mode of teaching and learning resources. So, very good luck. Module 1, Introduction to Companies Act 2013. Several attempts were made to make changes in the Companies Act 1956, which further led to the revamping and formation of the Companies Act 2013. This act has introduced several new concepts and briefed new definitions. This include one-person company, small company, dormant company, corporate social responsibilities, and definitions for private company. Moreover, it has also modified roles and responsibilities, investments, financial statements, etc. The Companies Act 2013 consists of 470 sections, 7 schedules, and 29 chapters. The 2013 Act makes an effort to introduce the culture of corporate social responsibility in Indian corporates by requiring companies to formulate corporate social responsibility policies and at least incur a given minimum expenditure on social activities. This is one among the major highlights of this Act. The objective of the Act include encouraging entrepreneurship, that is, bringing up entrepreneurs into the arena, encouraging transparency, accountability, and also highlighting the standard corporate governance, to set up institutional structure in the form of authorities, bodies, and panels, which can also enforce restrictions against fraud. These are some of the objectives of the Act. As per the definitions of the Companies Act 2013, the term company is defined as a company incorporated by this Act or under any previous company law. In simple, a company is a natural legal entity formed by the association and group of people to work together towards achieving a common objective. The Companies Act also identifies various kinds of companies, which we will be discussing later. The major features of a company include incorporated association, which means that a company's existence is when it is registered under the Companies Act or other equivalent act under the law. Another feature is that the artificial legal person. In the eyes of law, a company is an artificial legal person which has the right to acquire or dispose of any property, to enter into any contracts in its own name, and to sue and to be sued. Another feature is a separate legal entity. A company has a distinct entity and it is independent of its members or people controlling it. A separate legal entity means that only the company is responsible to repay the creditors and to get sued for its deeds. Moreover, a major feature of a company is a perpetual succession. A company is a stable business organization. Its life doesn't depend upon the life of its shareholders or directors or employees. Some of the kinds of companies are private company, public company, dormant company, associate company, one-person company, garment company, small company, etc. A private company is formed with minimum 2 members and maximum 200 members. The shares of a private company are offered, owned, and traded privately. The Companies Act 2013 does not allow private companies to trade their shares in a public platform. A company which does not come under the definition of private company and has a minimum paid up share capital of 5 lakhs and has an association of minimum 7 members with no restrictions in the limit of number of members is called as a public company. A company in which other company has a significant influence, but which is not a subsidiary company of the company having a significant influence. It also includes joint venture, is called as an associate company. The control of the business under these companies are as per an agreement. A company formed and registered under the 2000 Act 13 for future project and to hold an asset or intellectual property and has no significant accounting transactions is called as a dormant company. An inactive company can also apply to the registrar of companies to obtain the status of a dormant company. One-person company is a company with only one person as its member. This is a major highlight of the Companies Act 2013. It has been provided with concessional and relaxed requirements as per the Act. A small company is defined as a company other than a public company with a paid-up capital of which is not exceeding 50 lakh rupees or such higher amount as may be prescribed, which shall not exceed 5 crore rupees, or a turnover of in the last profit and loss account which does not exceed 2 crores or such higher amount as to 20 crore rupees. And a small company is not a subsidiary company or a company governed under special act. Any company in which not less than 51% of the paid up share capital is held by the central government or by any state government or governments, or partly by the central government and partly by one or more state governments, is known as government company. Moreover, it includes that a company which is a subsidiary company of such a government company also comes under this definition. Lifting of corporate veil. Disregarding the corporate personality and looking behind the real person who are in the control of the company is the meaning of lifting of corporate veil. When directors or whosoever in charge of the company commits a fraud or illegal activity which is beyond the boundaries of the objectives of the company or the articles of the company, this principle is initiated. That is, the legal entity of the company is displaced off and the real person behind the fraud is brought into the limelight. This module sums up briefing the Companies Act 2013. I hope the concepts are clear. Thank you. Module 2, Formation of Companies. We have understood what a company is, what are the features of a company, and what kinds of companies are there. Here we will discuss about the various stages in the formation of a company. Promotion is the first stage in the formation of a company. A person or a group of persons having a thought of or conceived a particular idea which is a possible future business opportunity, and then taking this initiative to give a practical shape of a company is known as promotion. The persons who look forward to form a company is called promoters. One among the major role of promoter is to identify the potential business opportunity. That is, it can be a new product or a new channel for an old product, or an old product with new features is all a part of business opportunities. Another role is the feasibility study, the whether technically and economically it is possible, or whether there is any applicability or whether there is any possibility for the business to work out. All this comes under the role of a promoter, and moreover preparation of the necessary documents also. Incorporation is a legal process to form a corporate entity or a company. In fact, a company comes into existence by the process of an incorporation. This includes the criteria to be followed by the company under the Companies Act 2013. Capital subscription. This is the third stage in the formation of a company. Here, the promoters decide the capital structure, what is their potential capital of the company, and how are they going to structure this capital. In case of public company, there are various legal rules to be followed while collecting the share capital. Commencement of business. A company gets legal approval certificate from the registrar office for the commencement of a business, of a particular business or a specific company. This certificate is known as the certificate of commencement of business. After verifying the documents, the registrar office approves for this certificate. The promoters may enter into some contract on behalf of prospective company. These contracts are called pre-incorporation contracts. They are also known as preliminary contracts. The contracts made after the incorporation of a company but before the commencement of the business is a provisional contract. These contracts are no more valid as per the amendment of the Companies Act. The base of a company or the heart of a company is the three documents: Memorandum of Association, Article of Association, and Prospectus. Memorandum of the company is the life-giving document. No company can be registered without this document. Memorandum of company contains the details of a company like capital, name, liability of the members, objectives of the company, and it also defines the limitations and powers of the company beyond which the company cannot spread its activities. The activities of a company should be within its object clause. Any activity beyond its objectives is ultra vires, is void and cannot be rectified. This concept is summed up in the doctrine of ultra vires. A legal document that serves along with Memorandum of Association is the Article of Association. It serves as the constitution of the company. Article of Association defines the purpose of the company and also specifies the regulations for its operations. Here we have the distinction between Memorandum of Association and Article of Association. Memorandum of Association is the life-giving document or the base legal document required for the registration of a company, whereas Article of Association is the secondary document as to the Memorandum of Association because it is constituted only after the Memorandum of Association. Memorandum of Association lays down the objectives, scope, powers and areas of operation of the company, whereas Article of Association lays down the rules, regulations for the administration and management of the company. Memorandum of Association lays down the limits or the boundary beyond which the company cannot operate, whereas Article of Association lays down the rights, responsibilities, powers, duties, etc. of the members. Doctrine of indoor management. Any person dealing with the company's affairs does not need to bother about the internal affairs of the company, and he should presume that the members of the company are performing their acts within the scope of their apparent authority, that is, the Memorandum of Association and the Article of Association. This doctrine protects the third party from the company or the external members from the company. Prospectus is the third major legal document of a company, a document which contains the detailed information of the company and which invites the public for subscribing to the share capital and debentures of the company. A prospectus shall be issued by and on behalf of a public company. Statement in lieu of prospectus is issued by a company which does not issue a prospectus. It is a statement which is delivered by a company having a share capital to the registrar for registration at least 3 days before its first allotment of shares or debentures. If there is any misstatement in the prospectus, the person who has signed and who has given the consent for the prospectus is liable for the same. It may be the managers, the company secretaries and directors, all come under this category. Here we have discussed about the various stages of formation of a company and the various legal documents required by a company. I hope this concept is clear and a deeper understanding is made. Thank you. Module 3, Share Capital. Here we will be discussing about what shares are and what are the different types of shares. A share is a proportion in the interest of the total capital of a company by a shareholder. A share represents fractional ownership in the company. A share is the smallest unit of the company's overall net worth. Types of shares are equity shares and preference shares. Preference shares are the shares with a preferential right for dividend payment and repayment. Here, the shareholders get a right for fixed amount or rate of dividend, and while repayment by the company, they get a fixed premium or amount as prescribed in the Memorandum of Association. Whereas equity shares does not have any preferential right, but they have the voting rights. When an issue of securities or shares is made to a new investor, that is, for becoming a part of the shareholders' family, it is called public issue. The process of selling and marketing of these shares and securities for subscription is done by issue of prospectus. Book building. It is a method of offering shares by providing a price range. The process where the issue of shares ends, the allotment of shares begins. That is, each individuals are assigned to a particular shares. They become the holder of that particular shares. That is, the distribution of shares among the shareholders who applied for the shares. Issue price of shares means the price at which the shares are offered for sale for the first time, and this becomes available to the public. For a company to trade its shares or to provide its shares in the public platform, it has to list its shares officially under the stock exchange. Employee stock option scheme is a favor given to the directors or officers or employees of a company or its holding company or subsidiary company for the right to purchase or to subscribe for the shares of the company on a future date at a predetermined price. Sweat equity shares are the shares given in favor of the employees of a company recognizing their work. These are the shares issued by a company to its directors or employees at a discount or for consideration other than cash for providing their know-how or making available their intellectual rights or value additions. The shares issued to the existing shareholders are the right shares. A right share is one way in which a company can raise equity share capital among the various types of equity share capital sources available. Shares with differential right are the equity shares with higher voting rights and which are generally given to the promoters, key managerial persons, managing directors, etc. The differential rights are in respect of voting power and dividend. Share certificate is a written document signed on behalf of a company that serves as a legal proof of ownership with the number of shares indicated. A document which is issued by a company evidencing a person named in such certificate is the owner of the shares of the company as stated in the share certificate. Share warrant is a document issued by a company under its common seal stating that its bearer is entitled to the shares or stock specified therein. These share warrants are transferable by mere delivery without registration of the transfer. Calls are a demand made by the company on its shareholders to pay a part or whole of the balance remaining unpaid on each share during the lifetime of a company. Forfeiture means the cancellation of the shares for non-payment of the calls due. A shareholder fails in his obligation, then he loses his entitlement to the shares he owns. Surrender of shares, that is, the return of shares by the shareholder to the company for cancellation. Here, the shareholder voluntarily returns his shares in favor of the company. Buyback of shares. Here the company buys back its shares and offers to purchase the shares held by the shareholders. It is also known as repurchase. Dematerialization. The short form for dematerialization is DMAT. It is the process through which an investor's physical share certificate gets converted to electronic format, which is maintained in an account with the depository participant. Rematerialization. As the name suggests, it is the opposite of dematerialization. It is the process of conversion of electronic holdings of securities into physical certificate form. Transfer of shares is a voluntary act of a member that takes place by way of contract. Transmission of shares occurs due to the operation of law. that is, in case the member passes away or becomes insolvent or lunatic. Transfer under depository. It is a system where the transfer and settlement of shares takes place not through the traditional method of transfer deeds and physical delivery of shares, but through the modern system of effecting transfer of ownership of shares by means of book entry on the ledger or the depository without the physical movement of shares. Here we have discussed about shares and what are the kinds of shares and the features in shares. I hope the concept is clear. Thank you. Module 4, Management of Companies. Here we will discuss about who are the key management personnel, what are their responsibilities, liabilities, and what are their qualifications and disqualifications. Board of Directors. They are the representatives of the shareholders, and the board is responsible for protecting the shareholders' interests, establishing policies for management, and overseeing the entire company. Directors. They are the persons who are elected by the shareholders to direct, conduct, manage, and supervise the entire affairs of the company. They have the responsibility to implement the company's policies. Women Director. The Companies Act 2013 makes it mandatory that there should be at least one woman as a director for all listed companies and any public company having a turnover of rupees 300 crore or more or a paid-up capital of rupees 100 crore or more. The Companies Act 2013 fixes the number of directors for a company. In case of private company, the minimum number of directors are 2 directors, while a public company must appoint at least 3 directors, and for a one-person company, as the name suggests, the number of director is at least 1 director. The position and power of the directors are mentioned in the Companies Act 2013. They have the right to inspect the books of accounts, they have the right to receive notices of board meetings, and they have the right to participate in the proceedings and cast vote in favor of or against resolutions. A director shall exercise all his duties and liabilities in accordance with the Articles of Association of the company. A director of a company shall exercise his duties with due responsible care, skill, and diligence, and shall exercise independent judgment. The qualification for a director depends on the type of the directors, but one qualification is mandatory for all, that is, it is clearly stated that the firm or a corporate or an association cannot hold the office of a director. The disqualification for a director includes if he is unsound mind and the court has clearly stated that. If he is an undischarged insolvent, he is disqualified to be a director. Moreover, if he is convicted by a court for any offense, he cannot qualify to be a director. A director can be removed from his position before the expiry of the period of his office after giving him a reasonable opportunity for being heard by an ordinary resolution. The key managerial personnel of a company include the chief executive officer or the so-called managing director or the manager, the company secretary, the whole-time director, the chief financial officer, and any other officers as may be prescribed. The system of rules, practices, and processes by which a firm is directed and controlled is known as corporate governance. Transparency of corporate structures and operations and the accountability of managers form the key aspects of a good corporate governance. Corporate governance ensures transparency and strengthens the balance of economic development. Moreover, it makes it clear the distinction of power between the board of directors and the management, and also the processes and procedures under which management is free to manage and the board of directors is free to monitor and give policy directions. Corporate social responsibility is the involvement of the company in the social activities that surrounds the company. It has a positive impact on social, economic, and environmental factors. In this module, we have discussed about the key managerial personnel and the features, powers, and the liabilities of these personnel. I hope the concept is clear. Thank you. Module 5, Company Meetings and Winding Up. Here we will discuss about what are company meetings and what are the features of company meetings and how does it become valid and when does a company go for the process of winding up. For a meeting to be valid, it should be convened by a proper authority. A quorum must be present. There should be a chairman to preside the meeting, and the minutes of the proceedings must be kept by the proper authority. Statutory meeting. Every public company that is a limited company and has a share capital shall, within a period of not less than 1 month and not more than 3 months after the date at which they have been entitled the certificate of commencement of business, holds a general meeting of the members of the company is known as statutory meeting. Every company other than one-person company must hold a general meeting in each year apart from all other meetings. This is known as annual general meeting. The annual general meeting must be held within 6 months from the closing date of the financial year. Extraordinary meeting. The companies can provide for holding of emergency meetings of the members which are known as extraordinary general meeting. Every company shall hold the first meeting of the board of directors within 30 days of the date of its registration, and thereafter a minimum number of 4 meetings in every year in such a manner that not more than 120 days shall intervene between 2 consecutive meetings of the board. Resolutions. They are agreements or decisions made by the directors or members of a company. There are 3 types of resolutions: ordinary resolution, special resolution, and unanimous resolution. In case of board meetings, there is no concept of special resolutions, and also unanimous resolutions are required in very few cases. Every listed company and every other public company having a paid up share capital of rupees 10 crores or more should appoint the company secretary in whole time employment. For appointing a company secretary, a board meeting should be held after giving notice to every director and also getting the approval of the terms and conditions at which the company secretary is proposed to be appointed. The duties and responsibilities of a company secretary include holding meetings of the board of directors and general meetings, aspects regarding memorandum and articles of association, maintaining the statutory registers, reports, and accounts. Winding up of a company is the process whereby the life of a company comes to an end and its properties are administered for benefit to its creditors and members. There are two modes of winding up of a company: compulsory winding up and liquidation under insolvency. Under winding up by tribunal, there are four types. First one is a petition by the company. Here the company can file a petition to the tribunal for its winding up when the members of the company have resolved by passing a special resolution to wind up the affairs of the company. Another type is a petition by the contributors. Another mode of winding up by tribunal is a petition by the registrar. Here the registrar may, with the previous sanction of the central government, make petition to the tribunal for winding up. And lastly, the petition by the central government or the state government. It happens on the ground that the company has acted against the interests of the sovereignty and integrity of India, the security of the state, friendly relations with foreign states, public order, morality, etc. Voluntary winding up, that is, when the members or the creditors, without the intervention of the tribunal, wind up a company, it is called winding up voluntarily. Liquidators. A liquidator is the officer appointed when a company goes into winding up or liquidation, who has a responsibility for collecting in all of the assets under its circumstances. The duties and liabilities of a liquidator include to carry on the business of the company so far as may be necessary for the beneficial of winding up of the company, to raise any money required on the security of the assets of the company, etc. The consequences of winding up include the powers of the company's directors get seized, the liquidator takes control of the company's assets, all the company papers must state that the company is in liquidation. The winding up order operates as notice terminating the employment contracts of all the company's employees, who are thereby automatically dismissed. So let's sum up. Here we have discussed about the different types of company meetings, how a meeting is kept valid, and what are its features. With this, we summarize the entire syllabus for corporate regulations. Thank you.